You use the hate speech provisions in the ICCPR Act to take revenge from your political opponents. But when men in robes come and use absolute hate speech, they are rewarded by being appointed chairman of the presidential task force. This is what happens. If you are in robes, you can speak, you can engage in hate speech as you like. That is what the executive thinks. And is this the way we are going to behave? This is why the international community has seen through this duplicity by the government. And that is why now you are forced to amend the PTA. But amending PTA alone won't do. You have to totally get rid of it.
Bismillah ar-Rahman ar-Rahim. Honorable Presiding Member, the Minister of Justice has presented 3 important bills that deal with amendments to the Criminal Procedure Code, the Civil Procedure Code, as well as the Judicature Act, which provide for the concept of pre-trial judges and some procedural matters connected to their functions. So this is a very welcome thing. All of us have no objection to this important concept being introduced. It will no doubt reduce the burden on trial judges to dispose of pre-trial issues expeditiously and perhaps save some time. Of course, the Ministry and the Judicial Services Commission will have to equip the system with men and material to make this a reality, which is a matter that everybody would concede. However, yesterday when I listened to the Minister, he was seen laboring the point that our judiciary is independent and that the ministry does not wish to unduly influence those in charge of judicial functions. Certainly none of us are accusing the Honourable Minister, who is a regular practitioner, who was a regular practitioner in the courts until he took over Cabinet Ministry, to be influencing judges. But then he laboured that point time and again to say that the government does not influence the judges. The fact is, the very basis of the 20th Amendment, the procedure of appointment of judges, promotion of judges, these matters being left exclusively with the executive, of course with a so-called parliamentary council, which is virtually a rubber stamp, results in indirect influence being exercised. And that is a fact. And that is why people are opposed to the 20th Amendment. Now, having said that, let me also say that laws delays will not disappear just because you make these laws and make sanctimonious pronouncements saying that we are a responsible member of the international community, that we never interfere with the judiciary. These sanctimonious comments are not going to simply make it possible for you to get over the problem of laws delays in our courts. Now, this government's record of abusing the Prevention of Terrorism Act to take revenge from their political opponents and innocent people has resulted in matters being referred to in resolutions before the Human Rights Council and resolutions being passed even in the European Parliament, resolutions being moved in the US Senate, then several members commenting on the human rights situation in this country and the way in which the Prevention of Terrorism Act is being abused in many parts of the Commonwealth countries, including United Kingdom, Australia, New Zealand, many countries. Parliaments, these matters do come up about matters regarding the abuse of the Prevention of Terrorism Act. This morning, in fact, when the amendment to the Prevention of Terrorism Act was being presented, when the Secretary General read out, I asked from the Honourable Foreign Minister regarding the issue that have been raised by the European Union in the Joint Commission discussion. There is a joint communique that has been issued. Now here, the paper says today, the EU noted that important elements had not been included in the PTA amendment bill that has been gazetted. Sri Lanka took note of the views expressed by the EU to take further steps to make the PTA fully compliant with international norms. I asked the Honourable Minister, are you going to move amendments? But he tried to avoid the issue, saying, no, we'll take it up when the bill is taken up for debate. So being as it is, now let's see how far it will be in keeping with the good practices in other countries. Now, because we don't have much faith in this government, because they have already the way in which this PTA is being abused. Now, latest fiasco.
The latest fiasco is the intemperate statement from the Ministry of Foreign Affairs targeting Ms. Ambika Satkunanathan, a respected former member of the Human Rights Council, for having appraised the committee of the European Parliament that was appointed to review the GSP Plus facility. Now, I would like to quote from the Financial Times. In fact, it says this way. Now, the Ministry of Foreign Affairs descended to new laws last week by issuing a statement publicly targeting Human Rights Commission of Sri Lanka, former member and prominent human rights activist, lawyer Ambika Satkunanathan. The targeted attack by the Minister of Foreign Affairs against a Sri Lankan citizen and human rights advocate for engaging in international mechanisms concerned with the deteriorating rights situation in the island was roundly condemned. Now, what do they say? The ministry claimed her submission to the EU Parliament was reminiscent of LTT propaganda. A veiled threat was being held out against this human rights activist. And this is a very unbecoming attitude, and this is a very, in my opinion, undiplomatic way of confronting individual. And then foreign ministry goes to the unprecedented levels of issuing a statement. And we are only becoming a pariah state by engaging in such fruitless exercises. Ultimately, now, as we have seen, these new provisions, of course, may reduce the misery of lost delays being addressed when it comes to pre-trial matters. But what of the long-suffering suspects against whom the CID, TID, CCD, and the so-called specialized agencies of the police who have been willy-nilly arresting people and on flimsy grounds and taking cover under the Provincial Terrorism Act, keeping people for 90 days at a time, some about 2 years or more. Yesterday, Hijaz Hizbullah finally was given bail after 22 months in custody. And I would like to quote from the order given by His Lordship Neil Iddawala, a former member of the officials' bench of this House. A very, very well prepared judgment. And here, what does Lordship Neil Iddawala say? The PTA is a result of a bill titled An Act to Make Temporary Provisions for Prevention of Acts of Terrorism in Sri Lanka.
Honourable Member.
A careful reading.
You have 2 minutes.
Beg your pardon?
More 2 minutes.
Yeah, I'll have 4 minutes, I think.
No.
A careful reading of the corresponding Hansard in 1979 clearly sets out the temporary nature of the statute, highlighting in specificity the contextualized enactment of the same. Reference was made to terrorism in the context of separatist ideology perpetuated by the objective to establish Elam. Then he goes on to say this, His Lordship, since then 4 decades have passed and the PTA has strayed away from its historical context. The PTA, if in its application and implementation, creates a vicious cycle of abuse, the very purpose of the statute will be defeated. However, it is alleged that the PTA has been utilized at times to the detriment of personal liberty by its draconian implementation. Ultimately, it is up to the legislature to ensure that the draconian elements of the law combating terrorism are dispensed with per modern-day contexts. Until such time, it is the judiciary's duty to employ existing legal provisions and constitutional powers to interpret the same elements in the interests of justice. Having said that, only he gave bail to Hijaz Hizbullah. So, no, this is what one of the former members of the officials' bench, distinguished member of the officials' bench, Justice Neil Iddawala says in the judgment. Now, having said that, let us see how these people. Now, I think it is important for us to also look at, leave alone PTA. Now, if we are to have some justice in this country, I believe that we also the judgments, Shani Abhaysekara's case, there again, there was a condemnation of fabricating evidence when granting bail to Shani Abhaysekara by Court of Appeal. There were other observations in many other cases. What about Azad Salih's case? In that case,
Yes, right up.
the judge, the presiding
Right up,
judge, saw the flimsy way in which the indictment has been presented. And he was finally released and acquitted from all charges. Right? This is the way in which you all are using the PTA and various other provisions. And particularly in Azad Salih's case, you use the provisions of the ICCPR Act, hate speech provisions. What
Thanks,
happens?
sir.
You
Thanks, sir.
use the hate speech provisions in the ICCPR Act to take revenge from your political opponents. But when men in robes come and use absolute hate speech, they are rewarded by being appointed chairman of the presidential task force. This is what happens. If you are in robes, you can speak, you can engage in hate speech as you like. That is what the executive thinks. And is this the way we are going to behave? This is why the international community has seen through this duplicity by the government. And that is why now you are forced to amend the PTA. But amending PTA alone won't do. You have to
Please sign
totally
up.
get rid of it and introduce a new act, at least a counter-terrorism act, separately, keeping with good practices, good international practices. This is what I say, Honorable Presiding Member. I know my time is up, but let me also say about a few words about this. The need to enact the contempt of court law. Now, what happened to Ranjan Ramanayake? Now, in his case, it was seen as an excessive sentence, 4 years. But of course, he may have been somewhat, his impropriety in uttering things outside this house may have landed him in trouble. But then the excessive sentence was an issue. But then, unfortunately, Ranjan Ramanayake's case, we feel a contempt of court law must be enacted. Discretion of courts also has to be properly streamlined and limited. And
Thank
that
you.
has to happen. This has been felt for a long time. There was something on the drawing boards. Senior counsel, Mr. Kanagiswaran, has presented a paper through the Bar Association for consideration by the Minister of Justice as well. A draft law was presented. That is there in the drawing boards. Contempt of court law is an important thing. Judicial Accountability Act is another one which is available in the in Singapore.
Thank
Then
you.
we also had to have a Sentencing Policy Act. Sentencing Policy Act, because there are variants of sentences between two judges for the same matter. And these matters needs to be considered, and I think only through these types of new legislation that we can ensure that at least a certain seminal justice would prevail in this country, particularly with the attitude of this government towards abuse of such special laws like the PTA and the ICCPR Act. Thank you.
Thank you.